Then it continues, in no case shall any force justified under the self-defense statute we just looked at give rise to any claim or action for damages or compensation against a person, employer, estate, on behalf of any person who brought the lawsuit, the plaintiff, who was committing or attempting to commit a forcible felony. So they lose their right to sue you, or was attempting to cause or causing unlawful serious bodily injury. So they were attempting to kill or maim you. And that applies both to the person who was trying to kill or maim you and their estate. So if you kill them in self-defense, their surviving family. They don't have a cause of action against you. They don't have a civil claim against you for your use of defensive force if these conditions are met. If a defendant files a motion for, I believe this is a motion for summary judgment. So it's a motion you can file before the trial even starts. Your Honor, even if every claim the plaintiff is making is true, they still would not be entitled to compensation. And if that's the case, if the judge agrees, then there's no point going to trial. You just dismiss the suit entirely. If a defendant files a motion for summary judgment and supports that motion with admissible evidence that establishes a prima facie, a more than 0% basis for the immunity we just discussed, the burden shall shift to the plaintiff to oppose the motion with their own admissible evidence, contradicting the claim of immunity in order to establish a genuine issue of material fact for trial. Really makes sense. You're making an immunity claim. The burden's now on them, the plaintiff, to disprove your claim of immunity. Fair enough. The plaintiff should always have the burdens. But sometimes the burden for various defenses is put on the defense. They're just making clear here the burden on the immunity claim. And again, we're just in civil court here. It's not criminal immunity. The burden on the immunity claim is on the plaintiff. Now, here's the facet that I found hard to believe when Sir Brass brought it to my attention, but is really interesting. And he was quite correct. In a civil case, so we're not talking, again, criminal immunity. This is not immunity from criminal prosecution, just civil. But we're going to bring the prosecutor into it from a flanking position. In a civil case, so you're being sued because you harmed somebody with force. So you're being civilly sued for the damage, the harm you caused. And you're claiming immunity because you're claiming that your conduct fits within the legal definition of self-defense. In a civil case in which an immunity defense is raised, the fact that a defendant was not prosecuted for a crime related to that use of force creates a rebuttable presumption that the defendant's use of force was justified. And the jury shall be instructed on this presumption if the case goes to trial. That is unusual. We're saying that a decision or the lack of a decision by a prosecutor to bring a criminal charge changes the civil landscape. Now, it's not obvious that should be the case. Prosecutors don't bring charges for all kinds of reasons. One big reason might be, hey, I've got to disprove this guy's claim of self-defense beyond a reasonable doubt at trial. I think it's 75%, 80% likely that it wasn't self-defense, but that's not enough to get a criminal conviction, so I'm not going to bring him to criminal trial. In civil court, all that's required for the plaintiff to win is 51%. That it was not self-defense. So if there's 75, 80% evidence against self-defense, that's not enough for a criminal conviction, but it's more than enough to win in civil court. So there's perfectly reasonable scenarios in which a prosecutor would decline to criminally charge, but it's still a viable case in civil court. Just look at the O.J. Simpson trial, right? Acquitted in criminal trial, found civilly liable in civil court when he was sued. But what this is saying is, should the prosecutor decide not to prosecute, not to criminally charge, and he doesn't even have to make an affirmative decision. If it just doesn't happen, the fact that you were not criminally charged now carries over to civil court to create a rebuttable presumption that your force was lawful self-defense, and the jury, if it goes to trial, is to be explicitly told that. Pretty good stuff. And if you're doing it in summary judgment, so before there is a jury, pre-trial, you're arguing to the judge, even if everything the plaintiff says is true, they're still not entitled to damages. If you're arguing in summary judgment, the fact that the defendant was not prosecuted for a crime related to their use of force shall also create a prima facie basis for the application of that immunity. And finally, we get the reimbursement language, which is common to many self-defense immunity statutes in any action, and they have a date here after June 30th, 2019, in which the defense meets these conditions for criteria. They're sued anyway. At the conclusion of the suit, they win. They win the action. The court shall award to the defendants any reasonable attorney's fees and cost incurred in defending the action if a defendant successfully moves for summary judgment on the basis of immunity. And the important word here, folks, is shall award. So if a defendant moves for summary judgment and it's granted on the basis of immunity, the court is obliged to award you, the defendant in the action, reasonable attorney's fees and costs incurred in defending the action. Sometimes these statutes say may award. And if it's left to the discretion of the trial court, they generally don't award those fees and costs, because in civil court, basically everyone pays their own fees and costs. That's the norm. So if you leave it to the discretion of the court, they revert to the norm. Everyone pays their own legal expenses. You don't get compensated for anything. But here they're saying you shall award the attorney's fees and the costs incurred if you win on the basis of immunity. But that's pretty common. The really interesting facet here was the bringing in of the prosecutor's decision not to, simply if a defendant was not prosecuted, it creates a rebuttable presumption in civil court, which the prosecutor has nothing to do with. It creates a rebuttable presumption in civil court that the use of force by the defendant was lawful under Indiana's self-defense law.